What does it mean to resist arrest? Resisting arrest and civil disobedience are not synonymous. When you physically resist arrest, you exponentially increase your risk of putting yourself, the officer, and the bystanders in grave danger. Is an unlawful arrest wrong and an extreme affront to your personal dignity? Absolutely. Should it cost you your life? Absolutely not. Police officers tell you that you are not legally allowed to resist arrest. Community leaders tell you that you are, in fact, allowed to do so. Who's right? You're not gonna like the answer, but the police are right. So, what does it mean to resist arrest? Frankly, the bar is surprisingly low. You resist whenever you struggle with, prevent, or delay an officer of an emergency medical personnel from performing the official duties, and you knew that they were attempting to perform the official duty, meaning they were in uniform or otherwise clearly identifiable as members of the law enforcement or medical personnel. Generally speaking, you resist arrest when you do anything, and I mean anything, to prevent an officer from placing you in handcuffs or putting you inside a squad car. This includes running away, threatening, intimidating an officer, verbally protesting, struggling with the officer, jerking your body away from the officer when he is trying to put your hands behind your back, spitting at, shoving, or headbutting an officer, or going limp or otherwise positioning your body in a way that makes the officer's ability to handcuff and restrain you more difficult. It also includes giving a fake name or personal information. The severity of the charge of resisting arrest will increase if the officer is physically hurt or requires any medical attention whatsoever. One exception has emerged in various jurisdictions. If the officer is using excessive deadly force to arrest you, you can defend to prevent death or seriously bodily harm. Unfortunately, whether the officer is indeed using excessive force isn't determined on the scene, but in retrospect. So it's not determined right there, it's determined in court. It doesn't matter whether you are resisting arrest because the officer is performing his or her official duty or during the performance of that duty. You can't excuse or justify your resistance by saying that you believe the arrest is unlawful. Under the majority of state laws, you can be prosecuted for resisting arrest even if the official arrest was unlawful. If you knew the person was trying to arrest you was an officer. Even if the charge for which you were originally arrested is dismissed or never even charged, the government can still prosecute you for resisting arrest. When you prevent an officer from trying to do his job, regardless of whether you think that performance is right, the courts will not look favorably upon you. Simply put, the courts are not on your side. People who are looking to justify resisting arrest will falsely tell you about the Supreme Court case John Badluck Al versus the United States. That you can use deadly force against an officer who tries to unlawfully arrest you. So what they're talking about is a court case where John Bad Elk versus the United States was basically saying that you could use deadly force against an officer if your life's in danger or something. But the thing that you have to remember is that this case was in 1900, like literally over 100 something years ago. But let me get back into this. All right. First of all, the case was decided in 1900. Yes, 1900. That was 20 years before women had the right to vote, 60 years before the passage of the Voting Rights Act, and more than 100 years before the election of the first African American president of the United States. Second, the case doesn't actually say that. The Supreme Court case never said that you are entitled to resist an unlawful arrest, and any statement to the contrary is misleading. What it does say is that when that particular a defendant was charged with resisting an unlawful arrest by an officer and killed the officer in the process, the jury had a right to know that the arrest was in fact unlawful when where they were deciding to be found guilty of a murder or lower charge. It is important for the jury to know whether the arrest was unlawful because it informed the deliberation of whether his resistance was justifiable in self-defense. Don't be fooled. The Supreme Court has not fully revisited this issue since 1900. Doesn't mean that you should rely on it to justify your own resistance. Remember, the Supreme Court interprets existing law. It does not create it. Its opinions are not relevant if there is a more recent law directly on point and that law has not challenged as unconstitutional. Since Badawi states enacted all kinds of legislation that criminalizes resisting arrest because constitutionally of those laws have not been challenged before the Supreme Court, you may abide by your state laws. Although you may have rightfully been acting in self-defense, when the officer tried to arrest you, you've got to prove that at trial, not on the streets. And as for whether your arrest was unlawful when you resisted arrest, you may have just given the officer a valid reason now to arrest you. It's a tough pill to swallow. So in other words, when you resist arrest and you're being combative, all right, you're giving the officer a reason to be aggressive and to harm you. I know it sucks, but if you get combative back and hurt the officer, there's a lot that has to be figured out during the trial process, and by that time you'll already be incarcerated.